name is Karen Chukwu, and I have my partner with me, Dimma Olisa. There are actually three of us,
Hello.
Trinity, but one is not here. Anyway, so today we're going to be talking to you about, oh yay, intellectual property rights and open source, the nitty gritty. Uh, Next slide, please. So yeah, there's an intro. We're going to talk about IP-related issues in open source and the types of open source software licenses. So let's get into it. And I'm just going to let them, take the lead on this for this particular. Next slide, please. Thank you.
All right. So here we are. I'm happy to talk about intellectual property. And you may be wondering what intellectual property is. It pretty much means the creation of the mind that is physicated in terms of it can be artistic work, can be designs, symbols, names, and images that is used for commercial purposes. That is what is called intellectual property. There are different types of intellectual property. We have copyright, trademark, patents, trade secrets, industrial designs, and geographical indication. But for the purpose of this session today, we'll be talking more on copyright, trademark, and patents.
All right. So I'm sure some of you can see the dummy thing there. Take it seriously, actually. You might come off as a joke, but I'm sure that you know that when building or contributing to an open source project, you're supposed to, review your license to ensure, to understand the kind of license that you have so that you're not infringing on the copyright holders' IP rights. Please, can we go to the next slide, please? Great. So, well, most of the issues that you find in open source are around copyright infringement. Number one, number one, and that's because copyright is that's because codes, your software codes, etc., actually are protected under copyright. I mean, like you generate this stuff, and so once you generate it, you're the copyright holder. And for someone who has already started like an OS, project, and you've probably seen it and you're going to build on it, that person is the license holder. And so obviously, contribute, use, modify, etc., you need to obtain a license from that person. So I would give an example. It's like using this venue now for this event, right? Now, Landmark is the event center owner, right? And we want to come in to use this place. What we've gotten from Landmark now is a license to use this place. It does not transfer ownership of the event center to us. No, it just gives us the license to use it for whatever purpose we wish to use it, as long as we're compliant to Landmark's terms. So that's where you find your license. I'm just trying to link this to open source. That's the importance of a license in open source. Another issue that arises as well is trademark infringement, patent infringement, very very important, and disclosure of confidential information. So for the trademark right now, there are entities that either start a project not just entities, even communities as well. An example could be Oscar. Let's say Oscar decides to start a project, right? Now Oscar obviously Oscar is trademarked, right?
Yes.
Now if you build on that project and you develop a product along the way at some point, you cannot obviously either create like a similar name to Oscar, or when I mean name, like the brand, right? You can't create a similar name, brand name like Oscar when you're trying to identify your products that you have derived after. This feels so weird because it feels like I'm whispering.
Yeah, right.
Okay, so you can't, do that, or else you'll be infringing on Oscar's trademark because they're the trademark holders, right? So the first thing I said was copyrights, right? And then followed by trademark. So copyright covers the code, all of the source codes that you're going to be contributing, building on, etc. Now the trademark is example Oscar, right? That name, that logo. So imagine coming up with a product and then you then go to put Oscar's name and logo there, and you're probably using that to even push your own products. Maybe you're thinking that if you put Oscar's name there, it will push your product, it will gain traction, etc. You are obviously infringing on their trademark rights because you have not gone to seek that license from them to actually use their trademark. The same thing applies to copyright as well. Now another one is patent infringement. Now patents are IP rights generated on new inventions, novel inventions, a contribution to an already existing invention that makes it new. But it has to be, the point of it is the end product must be new, or the process to get to the end product must be a new process, right? Now, when it comes to contributing to a project, right, or you've done something and you put it out there on open source or put actually contribute to it, chances are that might actually be like a new way of doing something. What you might not know is that someone has sought a patent over it or and obtained actually their patent rights over it. And the good thing about patents is you actually hold that right for 20 years. So if
Mhm.
anybody's going to try to use your work for 20 years, they need to come and meet you, which means that that's another way for you to cash out. I know when I say cash out now, people will start listening to me. Some people have been pressing phones since.
Big time cash out.
But when they hear money, no, but seriously, seriously, patents are definitely one way to actually make a whole lot of money. You find them a lot in the pharmaceutical industry, manufacturing industry, but even in the open source space as well. I promise you, if you contribute to, let me rephrase what I'm about to say. If you contribute to a project, right, and based on the license over that project, you are allowed to develop a new work and set out a product or whatever new source code that you have or whatever, and you patent it. That's cash money right there.
Mhm.
Do you guys understand me?
Yeah.
You guys get me? All right, great. Now, the reason why we have put disclosure of confidential information here is because now I know that a lot of us, contribute on our own individually, on open source projects, but some of us also work for entities, organizations, right? That obviously either contribute or make use of, source codes and other projects on open source, maybe like on GitHub or whatever, right? Now, your entity, once you join those guys, right? Once you join your employer, you obviously sign agreements. Your simple employment contract has terms within it, right? And for a lot of us that are working with maybe startups are still trying to get their structure up and running, right? And you'd find that they probably don't have like an internal policy, for contributions to open source projects, etc. Now, because they don't have it, does not mean that you can then go and do anything that you want to do. Because I promise you, once you make a mistake and your entity is going to go down for it, you as well, you go down for it, which is why we've included here disclosure of confidential information. When in
Yeah.
doubt, please always approach your employers, approach your supervisor, whomever that you think would obviously understand what the company's internal policies are, even though they're not on paper. Always approach them to understand the level to which you can contribute to a project or the level to which you can either copy, modify, or use whatever open source project or code out there. Are we? Are you guys still following me, please? All right,
Okay.
great.
Yeah, so I just want to add here that for emphasis on the patent infringement, right? Patent right is given to you where you wrote the source code yourself. So you don't go to the community, go to the open source, get codes, and then you modify it and feel, oh yeah, I have a right over this. So you do not have a patent right over codes that you did not write from scratch. So that's what makes it intellectual property. Are you with me? All right, thank you.
Said, in instances where you have contributed to something, a particular project, and you're like, wow, Eureka, I've come up with something new. Now, it's always best to obviously approach the copyright holder of that particular project that you've contributed to,
Mhm.
the source code, whoever owns the copyright over that. It's best for you to approach them and say, oh, I've done this using your codes and I've come up with this and I'm going to apply for a patent for it. You could either be, call patent holders, or as you're making profits of, whatever product you put out there based on the work that you have done using that person's source code, etc. You can either remit royalties to them as you make profits. It's always better, and we'll tell you why, anyways. Next slide, please. Great. So we have two types of open source licenses. So we have the permissive license, which pretty much carries minimal restrictions. So you can go, you can take the code, you can store it for your own use, you can modify it, whatever, and you're not even obliged to put it out. You're not even obliged to, put out your finished work back, you're not obliged to open source your finished work, right? But for the restrictive stroke copyleft licenses, once you actually build on those projects, once you build on those source codes, etc., you must make them open. The same way you came to meet it open, you must make it open for others, right?
Mm.
So it's very important to actually understand the projects that you're building on. Like always check, try to understand the license that that particular copyright holder has put out there for that particular project. So as you can see here, this is the open source initiative. This is just an example of what you may see on a license before you start building. It's always important. Like, I know that we're all excited to build, but it's always important to know what you're building on, because you never can tell when you would probably maybe find a solution to something, come up with a new thing, and then only to realize that, oh wow, I really messed. should have actually looked at. It's just like your terms and conditions, your privacy policy. A lot of us, just accept it without actually going through it. And I understand, honestly, it's bulky. Us lawyers, we deliberately make it that way so you don't have to read it, and then we make the font smaller. But when it comes to contributing on open source, I beg you, please go through the license for that particular project. Next slide, please.
Okay, and then just so you know, intellectual property rights are things that people do not take light at all. These are examples of the issues. I mean, look at these giants, Oracle and Google, D-Link and Wyland. If you infringe on any person's intellectual property, be it copyright, be it trademark, be it patent, these are big giants. I mean, like people like us, they will drag us like tiger gen. So you just have to be very, very check up with your licenses. If you need to obtain license for anything, with these people, for example, in D-Link and Wyland, D-Link feels that they had put in so much time, resources, and all of that into research and development of their wireless connection, and then D-Link takes product and then them out, though it is theirs, right? So they came after them. So if if big giants can come after each other, between the big giants and us, they will drag us without looking back. So you just have to be very, very careful, please.
I was going to say something, especially with regards to dealing. They literally had to recall that product.
Yes.
Now think about the amount of money spent on marketing. The team that works on it, obviously they've been paying them salaries, right? Think about all of that time, effort, resources, putting that product out there, trying to gain traction for that product and only having to recall it because the copyright holder over the product that they had built on obviously sued them.
Mhm.
And of course, I mean, once you agree to something, you've agreed to it. I didn't know it's not a defense in law. I did not know
Yes.
actually.
It's not an excuse.
Now with Oracle and Google, what we see here actually is a very dynamic case because I mean it's ongoing, and it's because obviously I mean Oracle is a big company, Google big, and some people are actually looking out to see what is actually going to be decided. Literally got to the Court of Appeal and they've been trying to decide and all of that, and pretty much what the Court of Appeal held was that Google's use of Oracle's Java was not fair use.
Yes.
So as you can already see, Google is a big, well, we can't use swear words, but yeah, forgive my friend, but I was about to say big SHIT. Actually go and read up on these cases and look up other cases as well. They're really prominent ones. And now there's some people that actually go around. So I know I don't know if any of you here have, like tried to probably like purchase a domain name. You find that that domain name has already been bought by someone, right?
Mhm.
And when you try to, purchase it, they reach out to you saying, oh, you have to pay so and so amount. Now there are people like that as well. Like when it comes to like intellectual property, there are people who just go and, obviously claim ownership of a particular thing. Like they just do something real quick, claim ownership because they know that they have done something vital that people are going to want to build on. Now, once they see that, oh, you have interest in this thing, they start reaching out to you. Oh, copyright holder of this and that. Yeah. Which brings me back again to you always need to understand the kind of license that you are working with. If you are working with a restrictive license, just know that after building, you put it out there. If you're working with a permissive one, all good and fine, you can have for yourself. So, like the
Yeah.
name implies, permissive, restrictive. Next slide, please. Now, what I want us to leave here with is number one, carry out due diligence before using an open source software or building on or adding to any project, whatever. Always carry out your due diligence. What that means is review the license before jumping in. The second thing is, as a creator, ensure that you have a license drawn up for your own project as well. You never know, where that project could actually take you to. So always ensure you have your own license drawn up. Of course, approach a lawyer for that. Entities should drop internal policies regulating the terms of use of all open source software, especially entities that obviously operate in the kind of market where they would need to. It's confusing when you do this, actually. Yeah. Yeah, but entities need to, have internal policies. So if you're an employer here and you know that most of your work will be around open source, definitely have your own internal policies that will regulate your staff on how to use open source projects, contribute, especially when they're building for your team or for your entity. And very important, carry out an internal audit. The way we audit our finances. Carry out to understand the kind of softwares you've built on, OS softwares you've built on, understand the licenses that apply to them so that you know where you start fixing your errors and you know where you give yourself a thumbs up. Lastly, always obtain permission from the IP holder of that particular project, source code, etc., before using that. And how to obtain permission, of course, is by agreeing to the license before you start to build. And if you see that you probably want to expand beyond that, then definitely reach out to them. Next slide, I
I
think.
think there's something you missed out. Contacting a tech lawyer. Please don't go online to download templates and all of those things. If you need help, contact a tech lawyer. All right. We hope you enjoyed your session.
A round of
Thank you.
applause for Karen.